Okay, welcome back to this meeting of the Net Zero Energy and Transport Committee. I inadvertently and wrongly missed out the fact that I should have said that we'd received apologies from Bob Doris, who was attending another committee meeting this morning for a stage 2 debate. So for those people that noticed he's missing, those are the reasons for. So we're now going to move into our second panel on the Ecocide Scotland Bill, which will focus on the international context. And I welcome Dr. Ricardo Pereira, Reader in Law at Cardiff University, Dr. Suita Ranhawi, who is a Senior Lecturer in Politics and International Relations at the University of West of England, and Dr. Rachel Killin, Senior Law Lecturer at the University of Sydney Law School. I'm going to start off, as I did with the last panel, and give you the easy question and give you each a chance to answer it. So, my question is, what are the key drivers in other countries that are developing ecocide laws? Is it because they're lacking anything, or what is the reason why they're being driven? Who would like to go first? Well, it's a bit of a rhetorical question, because I'm going to go to Ricardo first, if you'd like to start on that.
Okay, thanks so much for this kind invitation to be here today. Unfortunately, I cannot be present in the Scottish Parliament, but I appreciate the opportunity to present my views on the bill. I think certainly has been the case that since the independent expert panel in 2021, convened by the Stop Ecocide Foundation, released that proposed definition, it has since held a leading position in contemporary debates over ecocide. And although there were developments prior to that, you can trace back the history of ecocide laws to the 1970s, when proposals had been made over the criminalization of ecocide. Then, since several international bodies have since looked into the question of criminalizing ecocide, potentially adding an additional crime in the ICC statute. These proposals have never come to fruition. And I think many countries then decided to take the lead on criminalizing ecocide. I think this has been the case most recently of Belgium in 2024 with the amendment of the Belgium Criminal Code. And it is one of the examples that pretty much follows a definition that is follows very closely that independent expert panel's proposed definition of ecocide. Prior to that, we've seen France in 2021 having an amendment to its environmental code. So they are driven by the ecological crisis, by the climate emergency. There are a wide range of reasons that are at times given that we need additional tools, enforcement tools, to make sure that environmental crimes are addressed effectively. Certainly the most serious types of environmental crimes comparable to ecocide. And I think certainly it's been the case that since the European Union adopted a directive on environmental crimes, more commonly you'll see across the 27 member states criminalizing acts comparable to ecocide, so-called qualified offences. So, and also at the broader Council of Europe level, there is now a new convention, which is not yet in force, but also that criminalizes particularly serious environmental offences, which are also meant to be comparable to ecocide. And it should be borne in mind also that Scotland and the rest of the UK is also part of the Council of Europe. So I think there will be more and more different pressures from sometimes. Obviously, this started as a grassroots campaign, and there's been, for example, at the European level, much of the influence on introducing qualified offences comparable to ecocide was down to the work of the European Parliament, and pretty much working very closely with the civil society organisations. So I think this is a movement that is also being driven by international developments. But I think for that to be an amendment to the ICC statute will be still a long way down the road when this will happen, and that's partly why some countries are taking the lead on criminalizing ecocide, recognizing the seriousness of the ecological crisis, the climate crisis, And these are some of the key arguments that are sometimes made.
Okay, I'm going to go to Rachel next.
Yes, thank you. Thanks for having me along, and greetings from Australia. So I won't repeat what Ricardo has said in terms of the history and different states' perspectives. I think instead I'll focus on the motivations. So I recently coded the various speeches, background documents, public pronouncements of those that have been pushing for ecocide across different domestic contexts. And I think the number one reason is deterrence. I think there is a view that existing civil, regulatory, and criminal frameworks do not effectively deter large-scale environmental harm, and that there's a need for a crime that specifically puts on notice those in positions of power. So ecocide is largely conceived of as a crime of the powerful. And so there's an idea that you need people in C-suites to fear for their personal reputation and freedom in order to prevent large-scale environmental harm. So I think deterrence is the number one motivator, or at least in the public pronouncements, this is what comes through. The second most frequently mentioned justification is that it's expressive power. And I think you heard a little bit about that in the previous panel as well. That ecocide to some extent is symbolic. It's not only about what prosecutions may or may not happen, but it's to do with the moral condemnation of how we treat the natural world. And although we have existing criminal frameworks and civil and regulatory frameworks, we're not doing enough to make clear that there are some levels of environmental harm that simply should not happen. And so ecocide is part of that picture. And that's why it's been picked up so much in the last 5 years, as people feel, as Ricardo said, increasingly desperate about the climate crisis. And then there's the transformative implications. So there's a belief that through this more severe penal framework will urge corporations to fundamentally change their practices. Now, of course, there's a variety of regulations that already apply to corporations, including within the EU, in terms of their due diligence regarding environmental harm. But I think that's why the transformative and the deterrent justifications speak to one another. It's about removing things from being something that a business can navigate through, avoiding liability, to something where, well, no, you individually may face criminal penalties for this. So in Belgium, you really see the influence of particular members of parliament who had an academic background, who had done research into environmental criminal law prior to becoming politicians. And so you see the real shift there. And then in France, of course, you have the Citizens' Assembly and that kind of groundswell of push for the country to do something. So you have slightly different contexts. If you look at Latin America, for example, you really see a greater emphasis on the relationship between environmental crime and economic crime. So for them, it's very much about thinking about white-collar crime. So you can see that the specifics of domestic context also influence the particular approach that they take.
Okay, and I should have said at the outset, thank you very much for attending. I think it's 10:20 at night in your time. So it's
that's all right. Anything for the motherland.
very, very commendable. Thank you. Sarita, do you want to say anything?
Yes, thank you very much as well for having me here today. I won't sort of repeat what the other two witnesses have mentioned, but I think I would maybe articulate a couple of different points in terms of the key drivers in other countries. So I think already mentioned is the sort of broader context of, the climate emergency, as the UN calls it, the triple planetary crisis. And I think that obviously provides the impetus for change and action. Another big factor, I would say, in terms of a driving factor has been Stop Ecocide International's role whereby they have, I suppose it's a real success story of Norm entrepreneurship, where they have had an idea that has really kind of blossomed and taken root quite globally. So I would say that it would be important to sort of factor in how that international global social movement is also influencing the domestic politics, particularly of European states, but also further afield. I would also say then, based on how Stop Ecocide International has been framing this debate, has been by placing an emphasis on the relationship between criminalizing and justice. So in this context, I suppose what's becoming quite the mainstream view, given that we are also seeing lots of ecocide legislation being enacted, particularly in the EU, is the idea that meaningful climate justice can only be secured through criminalizing acts that amount to ecocide. So I think those are sort of some additional factors that are kind of also facilitating the drivers within particular local contexts. But I would also like to draw attention to how this is, of course, just one particular, I suppose, aspect of climate justice. Climate justice itself can be secured in many ways, and we have many examples across the world of how to do this in a way that may not necessarily involve criminalization. So, for example, we have seen sort of the rights of nature movement across the globe. But I suppose in terms of accounting for the tremendous rise of this discourse of ecocide and also seeing legislative change in particular contexts, I would say Stop Ecocide's role has been quite pivotal here.
Okay, so my next question is really, we've heard, I think, over the panels that we've had in relation to this, that we have fairly strong legislation regarding this Regulatory Reform Act, and there's been some suggestion that by adjusting the penalties might be just achieve as much as this bill. So my question is, in relation to ecocide, those countries that are looking at it, do they have such strong legislation as we clearly do in Scotland, or are they building on an empty bit of paper at the moment? Who'd like to go on that? By the way, if you all look away, that means I'll just have to nominate somebody. If you want to go on it, if you're remote, just raise your hand. If not, you've all looked away. So I don't know. Rachel, do you want to have a go at that?
Yeah, sure. I mean, so again, they all have different contexts. In France, they adopted quite a different approach in that this is just a more serious version of crimes they already have to do with pollution and waste disposal. So, of course, they already have existing criminal frameworks. They're just adding an extra layer of severity with intentional, more serious harm. In Belgium, I'm actually not going to comment on Belgium. I don't know enough about their domestic system. But in countries like Latin America, they are really trying to strengthen a relatively weak enforcement landscape. I suppose the thing that I would add to that is I don't think Scotland's pre-existing strong regulatory framework precludes the type of offence that Monica is proposing. Because I think there's still that need for something at kind of the apex of the regulatory pyramid. So in some ways, I'm not sure if your question is the right one, in that even in a country with a strong environmental framework, you could still have a discussion about a crime of ecocide.
Thank you, Rachel, but it is the question. So I'll go to Ricardo.
Sure.
Oh, so thanks very much for this question. I mean, I was very intrigued by the whole debate over Section 40 of the Regulatory Reform Act in Scotland. I mean, obviously, it dates back to 2014, and although I don't know enough about it, I suspect this new offence of serious environmental crimes has not been triggered by global debates around criminalizing ecocide. So it's a very domestic offence. So unlike the current international debates, There are some significant differences, for example, on how you define serious environmental offences and current conceptualizations of ecocide, including some definitions, a range of different definitions that are being adopted or proposed. It's a strict liability offence. So I think it is already clear from the bill that more likely there would be some higher threshold of mens rea, such as intention or recklessness or dolus eventualis. Also, the penalties are particularly low. I mean, if you look at even on indictment for legal persons, it will be up to 40,000, if I'm correct, pounds, and then up to 5 years in the case of imprisonment for individuals. So the penalties are much lower than has been proposed or adopted in a wide range of jurisdictions for ecocide or ecocide type offences. And they also, these Section 40 is particularly concerned with regulatory offences, so it's not an autonomous crime of ecocide. It's not to say that at the European level, because there was some reluctance of the member states to recognise those offences ecocide offences, so they are supposed to be qualified offences. It's not to say that they are that the offences at the member states levels would be autonomous offences. They will still be pretty much aligned with existing EU law, existing EU regulatory frameworks. But my sense is Section 40, as Rachel has already mentioned, I think it doesn't preclude a wider criminalisation of ecocide in Scotland. And I think for other countries, yes, there has been, since the 1970s, many countries started to introduce criminal offences to enforce environmental laws. And there was always a dependence with administrative law enforcement as well. So these environmental criminal law is in itself a very well-established field of law within environmental law or within criminal justice. But the particularly serious offences that require a prohibition, and as Rachel also mentioned, the symbolic and the deterrent effect of these offences is something that cannot necessarily be achieved through existing environmental criminal law. So I would say that probably most countries nowadays, a study from the United Nations Office for Drugs and Crime, UNODC, that shows a landscape of criminalization across the world. And it's very clear from that. It's not just global north countries that have strong legal frameworks for punishing environmental crimes. It's pretty much all over the world, including developing countries. It's just a matter of how effective the enforcement ultimately is. But I'd say ecocide is certainly a next step which probably could be the basis for a wider international criminalization of ecocide, starting from the domestic level and then eventually reaching the ICC. So I think that's my view on this.
Okay. Sarita, do you want to comment on that?
Yes, thank you. So I think it might be helpful to perhaps... So whilst I recognise that there's this important discussion around Section 40 and ecocide and the relationship and potential overlap and how would things kind of align in that sense, I think perhaps also to say, as Rachel has said, that it's perhaps the wrong question, and that's not to dismiss it as being unhelpful, but it's just to maybe highlight how it's important to contextualise how the issue here isn't only about whether existing law is sufficient. There are other kind of moving parts here, which I think we will lose sight of if we exclusively focus on this debate about Section 40. So, for example, another potential reason for criminalising a standalone crime of ecocide would be a response to existing limitations of current international environmental laws. I suppose here we could mention also the kind of global disillusionment with climate talks, climate negotiations. So this is kind of, in a way, one way to address some of those other limitations happening on the international field. And the other second point I would like to emphasize is the connection with criminalizing ecocide and broader foreign policy goals. So I think if you look at other countries who have created domestic crimes of ecocide, they are, for the most part, countries that also are strong believers in multilateralism, the rule of law, cooperation, particularly in the context of the ICC. And so here I think that in some cases, criminalizing ecocide domestically, because of the way in which that domestic goal has been informed by the social activism of Stop Ecocide International, there is a foreign policy dimension here as well. And I think that that might be important for Scotland to sort of kind of connect the two, because I think Scotland's quite progressive in its foreign policy agenda, and there is a very clear link here with criminalizing ecocide and also using that domestic legislative effort to further its own goals in terms of its external relations.
Thank you very much. I'm going to move to the other questions that we've got now. Douglas, I think you've got a few.
Yes. I did. I've just sort of lost my place. I was listening intently there. Where are we? Yes, sorry. So the committee has been considering whether introducing an ecocide bill will have a deterrent effect in relation to individual and corporate behaviours and avoid an instance of severe environmental damage. So are you aware of any evidence on how businesses or organisations have changed how they're doing because of ecocide laws being introduced? I'll maybe go to Ricardo first of all.
Okay, so thanks very much. Because these ecocide laws have been adopted relatively recently, there's even the Belgium law that was adopted last year, it will not be enforced until 2026. So there is limited evidence when it comes to this most kind of, perhaps you could call them more elaborate definitions of ecocide, because there has been some, a lot of brainstorming over how ecocide should be defined. Whereas if you go back to the countries that did have ecocide offences, like the former Soviet countries and so on, and Vietnam, for example, as well, as I understand, there's very limited evidence of actual enforcement, that there's actually these provisions have been effectively used in practice. So obviously deterrence can be linked to two things. One is obviously the levels and types of penalties, and ultimately as well on how they are enforced. So there are two aspects of deterrence: is the principle of criminalization, what ultimately the penalties will be, including imprisonment, fines, and other restoration orders and other types of penalties, and ultimately how likely these penalties would then be enforced. And so corporations will then take account of the entire legal framework to then decide due diligence policies to make sure that they would not commit environmental offences. There are studies suggesting that, for example, introducing new criminal offences do have a deterrent effect. But then once these criminal penalties are introduced, then manipulating the types and levels of penalties don't necessarily have the same deterrent effect. But certainly the principle of criminalization, which would be the case of this bill, would certainly add an element of deterrence. That's how I would see this in terms of my current criminological research on deterrence. But I think the practice when it comes to ecocide laws in different jurisdictions is very limited because of some of these laws are very new, and the other is that for the countries that did have these laws a while back, since the fall of the Soviet Union, there is not much evidence that they have been enforced in those jurisdictions.
So, Ricardo, you mentioned Belgium haven't enacted their legislation yet. And I don't know, has France, are they further down the route? And is there any evidence from there?
Apologies. A racial study most recently showed that there has been some investigations in the region around Lyon. So I've read some of the studies that Rachel has relied on her research on ecocide. So there has been evidence of investigations, but no successful prosecutions, as far as I'm aware, in France. But yes, the French law is supposed to apply a somewhat lower standard for ecocide, and that could arguably be a facilitator for prosecutions, because one of the criticisms of some of ecocide laws is because by applying a high threshold, it means that ultimately prosecutions will be very difficult to be, it would be very difficult to enforce these ecocide laws when you apply such a high threshold, which is typically described as so-called conjunctive definitions, that environmental damage is linked to both not only serious offenses, but also widespread and long-lasting or long-term. So all these three criteria of environmental damage must be present. Obviously, it depends on whether countries require intention. Also, recklessness is possible. My sense is that, from what I see from most jurisdictions, endangerment offenses, so offenses. And I think that's transpired in the current bills, that needs to, the illegal act must cause serious environmental damage. And so it's not an endangerment, it's supposed to be an endangerment offense linked to a potential damage from the offense. So I think my sense is that more and more countries are adopting a relatively high threshold to make sure, there is a fair labeling between what is a very serious offence and the very serious penalties that are supposed to be attached to these offences.
I'll maybe turn to Rachel now and ask about France. Rachel, have you got any more information about how the ecocide laws work in there, how many successful prosecutions there's been, and any changes that organisations have done because of the sort of threat of breaching ecocide laws?
Yeah, I mean, Ricardo's correct in that there have been various investigations launched in France, and there have been various complaints brought, victims raising ecocide with prosecutors seeking for investigations. The example that Ricardo mentioned is in Lyon. It's a factory, what was it? It's like a large-scale laundromat that had caused ground and water pollution that is currently, I think the investigation is still ongoing. So in terms of which country has gone the furthest towards investigating, the main example is France, and then also Ukraine, because one of the byproducts of this increase in attention to ecocide has been that Ukraine has renewed its interest in its own crime of ecocide vis-a-vis the invasion of Russia. So there's a specific body within Ukraine's prosecutor service that's specifically looking at ecocide in the context of their conflict. So that is moving forward. Now, Ukraine's definition is from that previous post-USSR iteration, so it lacks specificity. So they have been open that there's challenges around them actually pursuing this prosecution, but they are exploring that possibility. Now, that's obviously quite a different context to what we're talking about in Scotland, but it shows that prosecutors and investigators are realizing that there's scope here in different contexts. In terms of deterrence, it's mostly anecdotal because of how new all of this is. If you talk to folks within Stop Ecocide who are engaging with corporations, they will tell you that corporations are saying that it's on their radar, that they're thinking about how to preemptively get ahead of this. But of course, you don't really know if corporations are going to say otherwise to stop ecocide, given who they're talking to. But you do also see, and I think you can always track this in the aftermath of a state taking a further step along its pathway to criminalization. You'll see on various law firms' websites, explainers, advice to corporations as to how to make sure they are staying ahead of it and getting their house in order. And so at least in the way that law firms are thinking about their advice to corporations, you definitely do see a shift. Now, I don't know if you can call that deterrence at this point, but you certainly see a shift in the way the conversation is happening that suggests that there is some fear around the potential implications of a new crime. And to back up what Ricardo said, there is also evidence that in the context of environmental regulation, introducing criminal sanctions is slightly more impactful in terms of deterrence than civil regulatory frameworks, because deterrence relies to some extent on rational decision making. And we know that for many crimes, that's not an accurate understanding of why crime happens. But in environmental crime and crimes by corporations, that actually is slightly more true, in that when you are making decisions for your business and for financial gain, you are engaging in a cost-benefit analysis in a way that's not necessarily true for survival type crimes or crimes of passion. So there is some evidence that in this particular sphere, deterrence from criminal versus civil may be a little bit higher. We always need to be cautious, because with deterrence, you're looking for the absence of something, so it's a little bit tricky to measure anyway.
Can I just ask, Rachel, in terms of France, for example, so you mentioned there's been investigations, but has there been any prosecutions as yet? And when they introduced the law, was it replacing any existing law, or was it an addition to what they already had?
It's an addition in that they took existing offences of pollution and waste abandonment and then added a kind of, what do you call that word? A kind of, sorry, I'm really tired, a more severe version of those offences. So in that sense, the framework was already there, and then they were adding a more severe version. So in terms of has there been a successful prosecution completed, at this point, I haven't seen a successful prosecution completed. It's still, as far as I can tell, the case in Lyon is languishing in the investigatory phase.
Okay, thank you. Savita, anything to add on the deterrent effect?
Yes, thank you. I would like to also echo how it's probably too early to tell, just because these laws are in the process of becoming operational. And it would really take a sort of long-term study to really kind of track, the kind of issues that you're kind of are asking here, things like deterrence, successful prosecution, etc. I think it's important to note that no law can be a perfect deterrent. And, you sort of see this in even international criminal law, where, a crime of genocide doesn't necessarily prevent genocide from occurring. So I think that there's always going to be instances where the crime or criminal behavior will still occur. But the important thing then is what else is that law or crime achieving to do? So deterrence might be one part of it. But as Rachel mentioned earlier, that expressivist function of sort of underlining a society's censure or stigma about particular acts, but then also, of course, if you think about future generations, an educational component too. So, if, for example, ecocide sort of takes hold across the world, that would be something that, newer generations would be already taught compared to where we are now, where we're all kind of learning as we go along. But I suppose in terms of deterrence, a law or a crime is most effective in its deterrence if it's able to sort of strike at the heart of the power dynamics that go behind why that crime is being committed. So I think it would be important then if the key aim is to achieve deterrence, then the crime itself would have to sort of strike at the heart of power structures, such as sort of who are the actors that are able to commit ecocide and are able to get away with it. That's what the deterrence needs to kind of bear in mind.
But can we not do that by beefing up our existing laws as opposed to introducing a new law?
I suppose you could, but then you would also then need to be absolutely sure that the existing law has executed that function effectively. And in my understanding, the reason why Ms. Lennon is introducing this standalone crime is also to reflect the fact that existing penalties, existing legislation is not really kind of achieving its intended outcome insofar as, fines can be absorbed by corporations. It doesn't really give that kind of incentive to change behaviour, etc.
But we wouldn't have had an, if this law was in place, we wouldn't have had an issue in the last, I think we heard, last 12 years, or, I can't think of an ecocide incident that this would have caught. So I'm just trying to think how we need to, do we need to change behaviour if it hasn't been a problem up to now?
Well, it might not be the case of changing short-term behaviour, but certainly one of the functions of law is to sort of express a community's existing norms and provide a bit of a vision of what you would like that society to look like for future generations. So I think that would be important, especially in the context of how we live in an interdependent world. So, if Scotland has an ecocide law, that's not to say that its existing criminal frameworks were inefficient and it had to introduce another law. It's actually saying something else here. It's saying Scotland takes seriously its obligations, its climate justice agenda, and this is just one more thing it is doing amidst its existing procedures and policies.
Okay, thanks, Camilla.
I think, Rachel, you want to come in and then the Deputy Convener. Can I just say at this stage, I always get into trouble with the committee, but I try to balance the answers with the questions. And I have to live with all the committee members after today. And if I don't let them get their questions in because I run out of time, then my life becomes difficult. So I'm looking for short questions, short answers, but Rachel and then over to the Deputy Convener.
Okay, well, then I'll just keep it very short. It was just about if you haven't had an ecocide yet, are you going to have one in the future? I think I just wanted to say two things. One, you need to be thinking about what corporations based in Scotland do abroad. And I think that's a really live concern. And secondly, it's not like there's no ecocides happening in the United Kingdom. So for 10 years, I was based in Northern Ireland, where we're seeing, the death of their largest Loch Ness. And so to think that just because we haven't had one means there's none likely in future, I think is a misunderstanding of the direction that we're going in terms of environmental degradation.
Okay. Good morning, or good evening, of course, to Rachel in her case. And on that point, Rachel, can I just pick up an issue about experience in France and potentially in other parts of the EU where they've introduced an ecocide law? In France, did they move from an administrative liability process for dealing with environmental crime to a criminal-based liability scheme, which was one of the main changes that happened as a result of the introduction of their ecocide law? Is that correct?
So they introduced a climate and resilience law. This adds new articles to their French environmental code. So it's a qualified ecocide offence. Sorry, I'm looking at my own notes about it now. So where you have in the environmental law, you have two articles, one that talks about a general offence of polluting the environment. So that was a pre-existing criminal offence, and abandoning waste. They then could be qualified as ecocide with the additional element of intent. So that's the key difference, is the level of intention and then also the level of impact. And so they focus on serious and long-lasting, and they identify long-lasting as being at least 7 years. So this is an aggravated, that was the word I couldn't think of earlier, an aggravated pollution or abandonment of waste offence rather than creating new crimes. But they're building on a criminal framework.
Okay, that's helpful, thank you. Because I think some EU countries have an administrative liability scheme as opposed to a criminal liability scheme when it comes to environmental crime, which is obviously different from what we have here in Scots law. Deterrence is obviously one of the key themes that has come through in the answers we've had so far as to why you would wish to introduce a bill of this nature with an ecocide offence. you will have heard the evidence we received in the first panel, where the head of environmental crime at the Crown Office and Procurator Fiscal Service of Scotland was saying that they have been unable to identify any offences that they're aware of that were brought to them over the course of the last, say, since 2014. They were struggling to identify something that they could anticipate in the future that the existing law is not capable of dealing with. So if there's a lack of any identifiable evidence of cases over the course of the last, let's just say, 10 years plus, and our prosecutors are saying they can't think of other offences that could occur in Scotland that the existing law could not deal with, that this bill is seeking to deal with, where exactly is the deterrence from introducing a bill of this nature? Ricardo, can I come to you?
Yes, no, absolutely. And I've heard quite a lot of the, well, I've read quite a lot of the previous evidence that have been given to this committee on Section 40 that has not been effectively enforced or actually ever enforced. My sense, and then my research on UK environmental criminal law, so across a wide range of nations in the UK, show that when England adopted the Regulatory and Sanctions Reform Act of 2008, they introduced civil sanctions. There has been certainly a preference by the Environment Agency in England to use civil penalties, including also so-called enforcement undertakings. And there has been a displacement of prosecutions. And this has been the case also other countries like Australia that have introduced so-called civil penalties. So although there's been much debate throughout these committees on, Section 40 is difficult to enforce, I think there must be a look more holistically what is happening in Scotland. So, as was mentioned as well in the previous committee, that the sentencing guidelines of 2013 in England and Wales that had led to a significant increase in penalties, including criminal penalties. So that's something that Scotland could also consider sentencing guidelines. So there could be an argument that could be a more holistic look at the, obviously environmental criminal law is a broader field than ecocide, and so a whole overhaul of the enforcement system. But this is without prejudice, in my opinion, of introducing this very serious offence for the most serious types of crimes. Another point that was made in previous sessions was that, this is likely to happen every 10 to 20 years. Only this weekend, we saw the example of Southern Water in Essex, and it was, at least in the news outlet, is being presented as a major catastrophic event. Is it serious, severe enough? I think probably it is. Is it widespread or long-lasting? I think it's at least one of the two. Maybe it's localized enough that's not widespread, but certainly could most likely be long-term. So within the terms of the bill, 12 months, the environment could be recovered in the next 12 months. So the examples of water companies is very clear. In England, Southern Water was fined in 2021 19 million. Which was a record criminal fine. Then we had several high penalties also against Thames Water, 20 million. So we're seeing more regulators using criminal penalties, if not necessarily currently in Scotland, but certainly across the UK, you can see examples of regulators thinking, beyond only administrative penalties. It must be said as well that before these reforms, the Regulatory Reform Act of 2014 and the RESA in England 2008, the UK nations rely primarily on criminal law enforcement. So I think it is the case that the more regulators, like SEPA has now these civil penalty powers, it is certainly the case that there's a preference for them to apply those penalties directly than going through the courts, in this case through the Crown Prosecution Services, as is the case in Scotland. So my feeling is that, yes, there is a need for looking at the system more holistically. This is without prejudice, I think, of looking at the bill more, not only inward looking. I know one comment I was going to make is that obviously there's an issue here of competence as well. Yeah.
Okay.
There's a question of competence of Scotland dealing with this as an offence in Scotland. But I think looking more broadly, and I think it's the purpose of this panel to look at what other nations are doing.
Sorry, I'm going to have to interrupt here. Ricardo, you are in danger of getting me into trouble with my fellow committee members. It was a very long and full answer, of which there are a lot of facts in there. But I am going to have to impress on everyone the shortness of time, or I'm going to have to just go to a situation where I only allow a certain amount of people to answer questions, which will then upset the witnesses. So I'm asking you, please, to be as brief as possible.
Ricardo, can I just clarify, are you suggesting, based on the definition of ecocide within this bill, that in England and Wales, the regulatory authorities are issuing civil penalties for crimes that this bill would see as a criminal offence in Scotland if it was enacted, because it was ecocide?
Well, England, there was a bill before the UK Parliament for the criminalisation of ecocide, and I think it was supposed to apply to England and Wales, and that never passed, I think, the first stage, if I'm correct. So there's obviously no criminalisation of ecocide in England and Wales. It's just a matter of whether the regulators have a preference for criminal sanctions or administrative sanctions, because they have, in the end, discretion or a lot of bargaining powers that they can also apply. So this is supposed to be so-called responsive regulation, where they start from a warning notice and they start with the less, start with the carrots and then eventually applying the sticks. And that's one of the approaches that we see publicized by each enforcement agency of their approach to enforcement. That gives them a lot of discretion. I'm not saying that in England there has been necessarily a stronger emphasis on criminal sanctions, because since the Act of 2008, I mentioned before, also in England we have civil penalties, but then we saw similar reforms across the other nations as well. So that's my comment on looking at more holistically the entire system. But ecocide is a very specific offence, and it is supposed to be the most serious types of offences. But yes, there's little evidence on its enforcement currently.
Okay. Can I ask Rachel about the issue of deterrence, given that our prosecutors, the Crown Office in Scotland, are saying they can't identify any cases and they don't envisage, or they can't think of cases in the future that existing legislation cannot deal with in terms of a prosecution. Therefore, what is the deterrence effect of having a bill to criminalise ecocide?
Well, I think it comes from a couple of different places. I mean, one is that it's likely that the future is going to bring environmental risks that we're not currently having to deal with. In Scotland, I might think about North Sea engineering, oil field services, subsea technologies, things like that Scottish-based corporations might be involved around Scotland, but also further afield. So you might think about the deterrent effect of a serious crime in light of the possible future exploratory types of corporate activities that we're going to see as we, proceed down this dark path that we're on in terms of fossil fuel use. You might also think about how this fits into the global picture, and I think Savita was talking about this as well, that part of this is to do with building a kind of consensus around ecocide as a crime in order to facilitate an international crime. Now, I know that's not within Scotland's competency in terms of international crimes. But I think it can be understood as part of closing the loop, closing the places where corporations can hide from criminal accountability for severe environmental destruction. I think that's where it comes.
Okay. Suita?
I would just sort of have brief comments on how I think if the question is, does it have deterrent effect, the evidence isn't there. But I don't think that's a reason to be concerned in itself, because I think what's really happening here is just about sort of shifting the perception here, where ordinarily you would regard environmental destruction as destruction. But this bill is trying to say environmental destruction with these particular requirements, with the scale, widespread, etc., that is criminal. Right? And I think that the symbolic effect of that, especially in this global context, is powerful. So yeah, I'll just leave it there.
Okay, Mark. And I'm just going to actually, sorry, before we do that, I'm just going to say I've got a hard stop on evidence at 12:20, so I'm trying to put some pressure on people to give short answers. Sorry, Mark.
Yeah, great, and short questions. Okay, so the panel's already touched briefly on some of those definitions of ecocide. So severe environmental harm, widespread, long-term. Can you offer some comparison then with other jurisdictions, how they've defined ecocide and where you see the definition that sits within Monica Lennon's bill? Ricardo, I think you covered this briefly earlier on. Is there anything more that you want to raise in relation to how these terms are defined within this bill?
Yes, thank you for that. And I'd say the Scottish bill would probably most likely be perceived as one following the tracks of the independent expert panel's 2021 proposed definition for ecocide, because it follows, I would say, probably closely some of the core elements of it, with a few tweaks. I think when the bill was originally proposed and then following the consultation, there were a few important changes. I think there was a removal of wanton, and wanton is supposed to mean recklessness or dolus eventualis, and that had been criticized in the independent expert panel's definition because one is that many Rome Statute crimes, it's not possible to commit them through reckless acts. And the other was that the independent expert panel introduced a socioeconomic test as supposedly providing a shield for companies that that some of these environmentally destructive acts could be defensible if it was within the limits of sustainable development. So you can cause some elements of environmental destruction, but not if it's severe, significant, and widespread or systematic, or long-term environmental damage. So there is I think what's interesting here is because we may be looking at what is supposed to be an international crime in the International Criminal Court statute and what's supposed to be supposedly a purely domestic crime, which I think is what Scotland would ultimately do under this act. There are a few examples, I think, in Rachel's study, for example, the former Soviet countries had something more akin to international crimes. But I think more likely Scotland would have something more like a domestic crime. And I think the conjunctive or disjunctive elements, I mean, essentially is whether or not you require that the act is severe, long-lasting, and widespread, or severe and either widespread or long-lasting. So that if you have a disjunctive definition, then that's supposed to make it easier to prosecute or to establish that it's an ecocide offence. And one of the criticisms of a supposed conjunctive definition is that the environmental war crimes in the International Criminal Court statute has never been prosecuted because you're applying a high standard or a higher threshold that ultimately means a lower environmental protection standard. So it's a high threshold that ultimately means you can't enforce effectively. So we can have I feel tweaks from, I think what most jurisdictions are doing now is using that independent expert panel's definition as a baseline, and then adding variations to take account of domestic circumstances. I see, if you look at the overall bill, it's not just the definition of ecocide, but also penalties, there are defences. So there's a wide range of issues there that are supposed to bring this bill in alignment with existing Scottish law as well. So I'll leave it there.
Thank you, Ricardo. Rachel, do you have anything to add to that?
Yeah, I just wanted to say two issues I have with the Scottish bill. One, you say widespread if it extends beyond a limited geographic area to impact upon an ecosystem. I think that excludes the possibility of an ecocide that is specific to an entire ecosystem that happens to not be, so I think you should think about a definition of widespread that imagines the possibility of wiping out a species, but in a smaller geographical area. You could look at the Belgian example if you wanted to look at an alternative. And I think you should rethink having natural recovery within 12 months, because I think that is going to be difficult to prove. And I don't see a clear reason why you wouldn't just go with a reasonable period of time. And then the other thing to mention is that you could potentially also consider defining irreversible. And if you have a look at the guidance provided by UCLA on the implementation of the EU directive, they have some useful wording as to how you might think about defining irreversible.
Thank you. Sarita?
Thank you. I think I would just like to emphasize how we're really in unprecedented territory here. So maybe just to contextualize how criminalization has happened in the past. So if I take genocide as an example, we have states agreeing on genocide's definition first, and then it gets rolled out as a domestic crime within countries, right? So that agreed upon definition then animates the domestic definition of genocide. We don't yet have an international definition of ecocide, and I think we need to be cautious about relying so much on the IEP's definition. It certainly has received a lot of coverage, and it is indeed the starting point in many debates. However, when states, if and when they decide to define ecocide, there's a very high chance it's going to look very different to the IEP's proposal. So I'm raising this to highlight how what's happening before us right now is almost the opposite, where we're seeing definitions of ecocide domestically being created ahead of that international definition. So I think the lesson that kind of demonstrates is that whilst it might be useful to turn to other jurisdictions to see how they are defining it, there's also a limit in that as well, because as a domestic crime, it needs to work within the Scottish framework. So I think it would be very important to sort of just pay attention to maybe the not excessively borrowing how other countries are creating it within their domestic jurisdictions. And just to maybe add on, in terms of the actual definition in the proposed bill, I would also echo Rachel's view on the 12-month recovery period. That seems to be quite anthropocentric in its idea of nature and how it recovers. And I would also perhaps consider, if you know, and this goes back to the purpose of the bill. If the purpose of the bill is to protect nature, then some ambition is required, because I suppose we all talk about ecocide as if it's this sort of catastrophic event. And yes, that would be a very good example that helps us understand it in a situation where we haven't really quite seen it yet. But ecocide conceivably also can occur across a longer period of time. And you want to be able to make sure that the law speaks to those two sorts of instances.
Yeah, thank you. Convener?
Okay, thanks very much. Sarah, you've got some questions, followed by Kevin.
Yeah, it just actually follows on to that comment you just made there about it's not necessarily just a one-off catastrophic kind of incident, but in terms of the definition of ecocide in the bill, do you think it should apply to incremental harm or a course of conduct over time as well?
Most certainly, yeah, because of the danger of focusing on the spectacular, it runs the risk of replicating problems that we do see with other international crimes where, you know, there are many things that feed into a genocide occurring, and similarly, there are many things that will feed into ecocide. So I think it would be very important to consider that, yes.
Okay, thanks. That was a very sharp response as well. Thank you. I don't know if Rachel or Ricardo want to come in on that issue. Do you agree? Rachel first, I see.
Yes, I do. I mean, that's going to be a challenge in terms of how you prove ecocide, and it'll need to be something that you take into account in terms of things like limitation periods, things like that. I think ideally, of course, you would try to capture the slow violence of environmental degradation. I just could also see that being a challenge in practice.
And do we actually have experience in other legislatures who've taken that approach? You're saying
not explicitly. Yeah, I think there has been, to the limited extent that we have practice in terms of investigations, so far investigations have focused more on the spectacular. So with Ukraine, obviously, this is the demolition of dams. In France, I mean, in France, we're talking about the pollution of land over time, but still a relatively short amount of time. So we don't have examples that we can look to yet into a successful investigation and prosecution of the slow drip that actually causes the most environmental harm.
Thanks for that, Rachel. Did you want to come in briefly on that, and then I'm going to Ricardo?
Also add, I think in terms of trying to think about how we might sort of capture the spectacular but also the slower violences, I think it's worth reminding ourselves that this is just one particular tool in a range of other options. And I think it would be a mistake to kind of emphasize how this particular bill is going to do everything. It isn't. And I think sometimes it's really just necessary to think about how there might be other things Scotland can do in conjunction, for example, around the work on human rights and the environment, perhaps also debates around the rights of nature. And these would be complementary to perhaps an ecocide bill that is, of course, perhaps easier to execute in terms of catastrophic events.
Okay, thank you. And Ricardo, do you have a brief comment on that issue?
Yeah, so thank you. I'll be very brief. So my comment is essentially that we have a principle in criminal law that lacks SACTA principle, that the legal certainty. And if you have diffuse sources of pollution that happens through a long period of time, so it's a cumulative effect that is eventually leads to environmental damage, then it will be very difficult to assign responsibility to a wide range of potential polluters. So that's one consideration, whether cumulative damage is assigned to, you can assign responsibility to a particular polluter or a wide range of polluters. The other consideration about climate justice is that because although there's much emphasis on the climate emergency in ecocide debates, it is the debates around the intersection between criminal justice and climate law is a very infant debate. There's not much that's been done on this. For example, how we can use criminal law to enforce climate change mitigation obligations. But it's a very infant debate, and there is not much evidence that countries are actually using criminal law to enforce climate change obligations, including emissions obligations. So and this will be a very clear example of cumulative damage, obviously in a global scale in the case of climate change. But I'll leave it at that. Thank you.
Okay, thank you. I want to follow up with a question on thresholds for liability. And if you look at section 1 in the bill, it says that the person must intend to cause environmental harm or be reckless as to whether environmental harm is caused. And many stakeholders have agreed with this, but others have suggested that broadening liability to include negligence, as corporations might be unlikely to set out to cause severe harm. So to what extent is there any convergence or agreement across different jurisdictions on this issue and the appropriate level of liability? Have any of you got a view on that? I'm trying to read the room. Yep, Rachel.
Yeah, I think if you wanted to have lower threshold for mens rea for corporations, you could look at something like Chile's example, where they talk about the possibility of sanctioning corporations in the absence of sanctioning natural persons. They have a liability that arises from omissions of supervision. So this is something like serious negligence. It allows you to look at what steps corporations are taking to prevent large-scale environmental harm, and the attribution of liability really rests on that organizational fault, so failure of supervision, absence of effective prevention, or as they call it, like culpa organizational. Sorry for that terrible accent. So I think that could be one example that you might want to look at. Serious negligence has not been part of the international discussion because you tend not to have international crimes by negligence, but we are not talking about an international crime, we're talking about a domestic one. So I think you could explore negligence without necessarily risking over-criminalisation if you focused on corporate liability. I don't think that would be appropriate for natural persons.
Okay, thank you. That's helpful. I'm conscious we're running out of time here, are we?
We are indeed.
So I've got a final question about defence of necessity. It's included in the bill. Do you think it's important to have it for exceptional cases?
I'm going to ask you, Sarah, to ask one person to answer that question because we can't get through all of them in the time.
Have I got one volunteer who's going to be short and snappy?
You haven't got any volunteers.
No. No. I mean, people could give us a... Oh, well, Rachel, if it is going to be genuinely brief, because I don't want to rule out my next colleague.
If someone else wants to answer...
No, you're okay, in the firing line.
Okay, yeah, no, good. Look, I think this needs a rethink. I'm not sure the defence of necessity... I can't really understand how anyone is going to prove that. I think you're going to run the risk of running foul of Article 6. If you're tasking people with proving that on the balance of probabilities, you've got a human rights compliance issue there. So I'm not sure defence of necessity is currently serving you well, but I do think you'll need to think about some form of defence. I'm just not sure this is the right one.
Thank you. Kevin.
Thank you, Convener, and good afternoon, panel. The ecocide offence proposed in the bill does not include any defence that the harm was caused by permitted or licensed activity. That has raised quite a number of industry concerns and a lot of uncertainty. Do you think that this is a valid approach? And has this caused debate in any other jurisdictions? And if we could go to Suita first, please.
Sure. I'm not aware of any debate. That's just because it's outside my field of expertise. And again, my response here is also, I'll caveat it by saying that I don't have the specific knowledge, and my informed view would be that no defence is probably good because part of the reason for this bill is to sort of ameliorate instances where the licensing system is liable to abuse and creates loopholes that corporations can take advantage of.
So say a licence or a permit has been granted and it hasn't been abused, yet it is suggested at a later point that an ecocide event has taken place. What happens then?
But surely there should be safeguards within the licensing regime whereby any activities allowed by the licensing would be sort of limit to its own kind of boundaries, right? And so I'm sort of finding it difficult to imagine a situation where a license has been granted and yet it results in an ecocidal
Okay.
circumstance.
We probably don't have time to go into all of that aspects, but you know it's been suggested that that may be the case. Ricardo, please.
One approach that could be followed would be similar to the EU Environmental Crime Directive, in which Essentially, a license can be, you have the license shield for most of those offences. There must be a breach of either European law or national laws. And then there's an exception, which is when the licensee or the operator acts in a manifest breach of substantive legal provisions under a license, or the license has been obtained fraudulently or under the circumstances involving financial crimes, then that cannot be a defence. So that's potentially one way in which you can embed some sort of, there will be an element of a license shield, but you could have exceptions when there's a manifest breach of a license conditions or fraud, yes.
How have they dealt with this in other jurisdictions, or do you not know? We're not hearing you, Ricardo.
Sorry. This is a common defence in environmental criminal proceedings, that we are complying with our license terms, and whereas this could be potentially an administrative infringement, it may not amount to a crime because the criminal offences are dependent on breaches of administrative law, including the terms of a license. So it's always been a problem that is a license shield that is, and so the European legislators have tried somehow to move away from overtly reliance on this defence that the operators have.
So I get all of that, but the point is that the bill as it stands at this moment does not include any defence that the harm was caused by a permitted activity. Is there any other jurisdictions where that defence is in play in their legislation?
Yeah, I would say that there is exceptional that countries have so-called autonomous environmental criminal offences that a license cannot provide a defence, but this tends to be the most serious types of environmental crimes.
Okay. And if we could go to Rachel, please.
Yeah, it's unusual to have an autonomous crime of this type. You know, Belgium uses the language of unlawful. I think this is more common. If that's a barrier, then I think the EU directive is a useful framework for you to rethink this. You could have unlawful, and then you could have, as Ricardo says, this manifest breach of relevant substantive legal requirements. And I think you should join up thinking about that with the work you're doing around the right to a healthy environment, because you could have a situation where the behaviour is in line with a licence but fundamentally violates the human right to a healthy environment, and that could be one of the ways you balance that.
Okay, I'll leave it there. Thank you.
Thanks very much, Kevin. Now, Monica, I'm going to come to you, but I'm sorry with the time. You get one question and one question only.
Okay, thank you, Convener. The Scottish Government wrote to this committee in September to signal its support for the proposal to introduce an offence of ecocide. Notwithstanding what Suita has said today, the Government has been clear that they see this as being the most extreme, willful and reckless cases of harm. I just wonder, maybe, I don't know if there'll be time for everyone, so maybe I'll just come to Suita since I've mentioned her. Do you understand why the Scottish Government have framed it in that way, to make that distinction in people's minds that we are talking about the most severe examples? And are there other ways that, I suppose what you described as like the slow burn or the cumulative impact, could that be addressed under the existing regulations that we have in Scotland?
Yes, so I certainly understand why they framed it in that way, because of course this is in a way capturing why we are talking about this new crime of ecocide. It's to capture that spectacular. But I don't think it's a problem that if the bill doesn't capture everything, but then I think legislators do need to be aware that there are other ways in which those different sort of aspects can be covered by other policies and initiatives. So I wouldn't necessarily place all my bets on the one, because no law is perfect. So in that sense, it would be fine to kind of focus on that spectacular in terms of conveying to the public why it's there. In reality, I think you want to avoid being in that situation. And this goes back to the point about deterrence. It's a good thing that we don't have to use the law, because the risks of using the law demonstrate that something's gone very, very wrong.
Thank you. I don't know if you've got time for any more answers, Convener. I'm in your hands.
Well, I did have a hard stop at 12:20, and so I'm afraid I am going to have to stop it here. We are 7 minutes past that. I'd like to thank all the panel members for giving evidence and in such detail today. And Rachel, a special thank you to you. I think it's now 20 past or nearly 11:30 at night where you are. I think it shows remarkable fortitude that you were able to give evidence at that time of night. I'm not sure I could have done, but thank you very much. And we're now going to move into private session. Thank you.